Thank you so much. We're delighted to be here. As Kelly had mentioned, I'm Su Ming Ye. I go by Su Ming, and I'm the executive director of the Pennsylvania Institutional Law Project. And I'm really delighted to be joined by Sierra Shamer and Alexandra Morgan-Kurtz. And we represent the entire state, sort of. I'm in the Philadelphia office, Sierra's in Lewisburg, and Alex is in Pittsburgh. So we're really delighted to be here. I'm just going to start off by saying what we're going to each cover, and hopefully at the end, we'll leave time for questions. So I think, and I forgot to ask Kelly this, but I think you should be able to either ask questions through the Q&A or chat, and I'll just keep an eye on that. So the first, correct. Is that okay? Great.
Yeah.
So the first person who's going to go is Sierra, and she's one of our amazing paralegals with our organization, and she also, I should clarify, she's with the Pennsylvania Institutional Law Project and Lewisburg Prison Project. We have a collaboration for that office, and she basically communicates, writes, and talks to hundreds, maybe thousands of people a year. She's on our front lines, and so really has become an expert in her time with us of communicating with our client base and their families. So she will start off with some nuts and bolts and also some practical tips on communicating with people who are incarcerated. And then Alexandra Morgan-Kurtz, who's our really fantastic managing attorney in our Pittsburgh office, will give an introduction to the right to medical care while you're incarcerated or detained. And then I will finish up with more specifics on access to, or trying to seek access to, medication for opioid use disorder. So I will kick it off to Sierra.
Okay, thank you. So I'm going to be talking about communicating with incarcerated clients, and then later on communicating with their families. So I'll start with some overall tips and then specifically talk about legal mail, legal calls, and legal visits. So the first overall tip would be to make sure to listen and acknowledge what incarcerated people are trying to communicate to you or talking to you about. So many people who are incarcerated have very little outside help, assistance, or contacts. And oftentimes, at least in my experience, I or our office might be the only people that they are able to talk to or communicate with who's on the outside. And so listening to and acknowledging their situation, what they're going through, is really important. Even if you know off the bat, you may not be able to help them with their particular issue, hearing them out and listening can be a really, really big thing. And we've gotten feedback about that repeatedly, that people appreciate this. And then the second thing that I have in an overall tip is to be really clear about what you can and cannot do for somebody who is requesting your assistance, when they're incarcerated. And this is because we might be tempted to say, oh, I can look that up for you, or I can send that to you, or I can try to figure this out. You may not be sure if you're able to or not, but you want to give some helpful information, or you want to make that person feel good, in that particular situation in the conversation. But unfortunately, for many people who are incarcerated, they've been told, offered, or promised information and things that never happen, and that can deteriorate trust with people. And building trust is really important, especially in a client relationship. But just in general, you want to make sure, only say that you can do something if you're absolutely sure that you can do that task or that assignment for them. So those are the two overall things that I've learned in my experience and I found helpful for communicating with people who are incarcerated. So then I'll go now into specific modes of communicating with people confidentially. The first is legal mail. So the first thing you want to do with legal mail is to confirm the client's location. And you can do this with inmate locators usually, or offender locators, depending on what system you're looking up. I use the BOP inmate locator, the Pennsylvania Department of Corrections, and then some county jails have them and some don't. So you may not be able to locate your client in the county jail system. So in that case, you could also try VineLink. VineLink, I think, is intended for families or victims of crimes to be notified if somebody's released, but you can also look up and find where people are currently located. So usually you need to have their name and inmate number or institution number to look somebody up. If you have their birth date, sometimes you can also look them up, but usually you at least need their name and number. For people with very common names, there might be multiple of those people on the locator. So you really want to make sure that you're getting the right person when you confirm your client's location. And I usually do this the same day that I intend to send out legal mail to somebody, because people can be moved, and you want to make sure that, you know, the day that you send it out, they're at that location. And then the next thing you want to do is confirm the institution's legal mail procedure. And I think over time, this has changed, and it is constantly changing in a lot of situations. But if you don't have the correct legal mail procedure, your mail can get rejected, and your client may not be aware that you even tried to send them mail. So the three incarceration institutions we have in Pennsylvania are county jails, the Pennsylvania Department of Corrections, and the Federal Bureau of Prisons. And each of them has different ways to send legal mail. Probably the most technical system or requirement is the Pennsylvania Department of Corrections. And I do have in the materials a quick guide to sending legal mail. I might try to share my screen and show you that. Can we see that? Hopefully. Okay, so the first thing here is the Pennsylvania Department of Corrections. So I have a sort of generalized letter here. On the side of this info sheet are the absolute minimum things that you need to have in order to get your mail sent through. You need to have a full return address for your organization, your law firm. And then you need to have an attorney control number sticker and a weekly code sticker. These have to be requested by you to the Pennsylvania Department of Corrections if you don't have one already, and you have to wait to get that information before you can print it on the sticker. And once you register with them and you have that, you'll be able to receive these weekly code or time code numbers every week. And if your legal mail is rejected or there's an issue with it for whatever reason, they should email you and let you know. They should, they may not, but they're supposed to. So you definitely need to have your attorney control number sticker and your weekly code. And these should only be on the outside of your envelope. You should not have this information inside the envelope or the letter for any reason. The weekly code, even if you send something on a Saturday and it arrives on a Monday, there is a little grace period, and the institution will still accept it. Sometimes they will call you if the code doesn't match, and you can just confirm that legal mail. The other important thing is that you need to have a legal mail address, which is on the institution website for each institution in the PA-DOC. Some of you may be familiar with, or may not, that in the DOC now, non-privileged mail or regular mail is sent to a third party in Florida called Smart Communications, and they scan that mail, and then they provide those scanned copies to the people who are incarcerated there. So this is not a confidential way of communicating. If you send mail that's identified as legal mail to Smart Communications, it will be returned. Your client will not be notified that that mail has been returned from Smart Communications. It could also take a long time for you to receive that return back. So you want to make sure that the legal mail address is the one that matches the legal mail address on the institution's website. And then you also want to confirm your client's name and number as well, and you can use the inmate locator to do that. So those are the main elements for the Department of Corrections. Like I said, you may or may not be notified if there's an issue with your mail being received there, but they should email you. And if you don't, you can always email the DOC or call the institution and try to figure out what happened. So then we have the Federal Bureau of Prisons. The key elements here are that you need to have a white envelope. That's important. And when you identify your mail as special mail, which is legal mail in the BOP, you need to identify the attorney or the lawyer as an attorney at law. You can't use Esquire, or the name of a law firm isn't enough. It has to say attorney at law. And that's the BOP's way of saying, oh, this is a legal mail, this is from an attorney. And then you also want to have the institution address, PO box for that institution. Some BOP institutions have started to use smart communications, but to my knowledge, that's been temporary, and their legal mail addresses should still be their institution address. Sometimes the BOP facilities will call you to confirm that you sent the mail. And in that case, you just confirm, the client's name and number and the date that you sent it, and then they should deliver that to your client. All right, and then county prisons and jails. Honestly, there isn't a uniform way to address these envelopes, but you do at a minimum want to make sure you have an attorney name on the envelope somewhere identified. You want to have the mail identified in some way as legal mail or special mail. For us, we use a similar language that we use for the BOP. And then you want to get the client number if you have that, but if you don't have that, you can often send the mail without a client identification number. And then if there is a legal mail address, you want to use that. I do know there's a couple of prisons in our area that have used third-party mail scanning companies similar to Smart Communications. You want to make sure not to send it to those locations and to send it to the legal mail address. And then, I have a footnote here that says to check the policy. So if there are county jails that are starting these third-party systems, sometimes they may not have the information for the legal mail address on their website. They may not have put it up. So you want to call if you don't see that, and if you're concerned that it may not get to your client. But I think overall the message is, the most important thing to do is to do your research and look it up to make sure you're trying the best that you can to make sure the mail is received by the client and that mail is confidential. All right.
And I'll just jump in just to say that from an attorney point of view, it is really important to try everything you can to make sure that communication is protected. One, to protect attorney-client privilege, but also, unfortunately, our clients, if by accident we've made a mistake and sent it so it's not covered, the staff often will open and read it. And unfortunately, we have had clients who suffered from retaliatory measures. So it can be really confusing. I think the main thing, as Sierra said, is to check.
Yeah, and I'll also add, even if you might have a reasonable expectation of confidentiality with your mail, sometimes when I'm writing to people, of course, the issues that we write about are issues that occur in the facilities and may involve staff members of that facility. I do sometimes intentionally decide not to explicitly write the names of staff or things like that, that it should the staff read it or it get in the hands of somebody else in the facility, there'd be a less risk of having negative effects on the client. So I should also add that the stickers do say that they're supposed to only open the mail in the presence of the inmate. So that means that, that person's going to be called into the mail office or a special room where they can sign for their legal mail, and the staff will open the mail and check it for contraband. They're not supposed to, however, they're not supposed to stand there and read it. So we have had reports where people felt that the staff were staying there too long with their mail and they felt uncomfortable. But so they're allowed to open it, but they're just not allowed to thoroughly read it. And it has to be in the presence of the client. So the next thing I'll talk about is legal calls. And during COVID, I think we've done a lot of legal calls, especially because we haven't been able to visit people. But a lot of this is similar to legal mail in that you want to confirm the location and ID number for your client. When I set up calls, I like to have all of the necessary information right in front of me. So sometimes I'll call and I'll have to have all the information, and I'll set up the call right on the phone if I manage to get a staff member at that time. Sometimes I'll be given an email or a contact phone number for a counselor or something else, and I won't be setting up the call, immediately, but I'll have to do some follow-up action. It's hard to say what you're going to end up with when you go to set up the call, which is why I like to have all the necessary info. And that information is, your client's name and prison or institution identification number. If you're an attorney, you want to have your attorney ID. Or if you're a paralegal like me, and you're setting it up for an attorney, you want to make sure you have the attorney's ID that you're setting it up for. And then you want to have a contact number for the legal call. So that's going to be the number that either institution will call you on the date of the scheduled phone call, or the contact number for you, so that if you call them, they're able to get in touch with you. So that could be a conference line or whatever contact number that you prefer. And then you also want to have your availability in front of you, so that if you are in the situation where you're asked when you want the call and you're right on the phone, you'll have that in front of you. So I have all of those things to set up the call. So for the BOP, just some tips that I've found that it's easier to set up and confirm legal calls doing it through email, especially if you get the counselor's email for your particular client. If it's a new institution that you've never set up a call at, I'll either call or I'll use their administration email, which is right on their website. And I'll put the information in saying I'm requesting a call. They usually forward that to the client's counselor, and then the counselor will email me directly. And that way I can use that person's email to set up calls with that client into the future. And it's very easy, and it takes a lot less time than trying to call the administration directly or email the administration. For other institutions, it really depends. So for the DOC, sometimes you can call and speak to the the superintendent's assistant, and you can set that call up right away. Other times they'll have specific legal call emails that you have to submit. Sometimes you can do it just by email, and sometimes they'll ask you to write the request on letterhead and then email that request in order to get the call. Then they will confirm that with you, and you'll have all the necessary information to complete the call with your client. And then county jails, it really depends. For county jails, I usually just call straight away. And then depending on their system, it might require an email, or I might be able to set it up. So it really depends. The most important thing is to have all the correct information and to have the contact information of someone, or a phone number, email, in case there's an issue when the call happens. So this has happened to us frequently, where we'll have a call set up and maybe 5-10 minutes go by, no one answers or something like that. And that way you'll have a contact for the counselor, you'll have a contact for the institution, and you can kind of troubleshoot and see what's going on. The other thing that's important with the call is to make sure that during the call or with your client is comfortable, and that the call is confidential. And this can be hard to determine sometimes, but what I will do is ask the client if there's anyone in the room with them. Is the door closed? Do they feel comfortable in the situation? Or is the phone on speaker, or is it handheld phone? And then if the client for some reason does have a staff member in the office, and that staff member either is not able to leave or refuses to leave, you can ask your client if they're comfortable proceeding with yes/no questions. So that way you can still go through with the call, but there's some confidentiality there. So we have had those issues happen, and sometimes if they're not comfortable, you have to reschedule, or you can see if you can request the staff member leave or the door be shut or whatever the issue might be. And then, so then sometimes your scheduled call might be canceled, and you could be given many different reasons for that. During COVID, we've had people say they're on quarantine, they can't, there's no confidential location for a call, or we've had people say that clients have refused. Now, this may or may not be the case, and it's always important that if you get a note that your client has refused the call, to follow up as soon as possible with your client to confirm that and to find out if there's any issues or if something's going on. Sometimes they have refused, but a lot of times there's other things going on at the institution that might be a reason why the call couldn't be completed. Alex, you're assuming, do you want to add anything before I go to visits?
And one small thing on the legal calls and the confidentiality, especially with county jails, depending on how often they've had to deal with legal calls, the staff can be a little flummoxed when you ask for it be confidential, and they just kind of assume that they can stay in the room and listen in. And so it's really one of those moments where you need to be a very, persuasive advocate and stick to your guns on the fact that your clients do have a right to a confidential call with their attorneys. And if you can't get that call, then, sometimes it's just better for your client interest, even though you have your client on the phone right then, if they're not comfortable, to just hang up that call and then follow up with the warden and talk to them about how you need to have a confidential call, and they need to make arrangements for that to happen. And so that's definitely something that we get pushback from a number of county jails, depending on the circumstances. I'll also note that since COVID, one thing that has changed is some of the bigger county jails do now offer confidential Zoom calls for legal calls. They'll call them legal visits. I categorize them in the legal calls. But so, for example, both Philadelphia city jails as well as Allegheny County now do have confidential Zoom visits. And you need to make sure when you're signing up for the visits that you're signing up for the confidential attorney ones, because those jails do also offer family visits, and the jails definitely record the family visits. So you want to make sure you're using the links to set up the confidential attorney visit so that it's not being recorded.
The one thing I will add is that we have run into issues too of a county jail, particularly the county jail, refusing to set up a legal call, or sometimes they'll say, give us 3 times you're available and you have to wait for the call. So we have actually had to do a bunch of advocacy, sometimes asserting our right to a legal call. And if you run into that, feel free to reach out.
If I could just interrupt too. Sorry, this is Kelly. I just need to launch the first CLE poll box. Attorneys, you will have 2 minutes in which to respond to the question poll box. Again, this is the first of 2 and you must complete both. And please feel free to continue. Thank you.
The other thing I realized I focused a lot on when we would be calling the person. In the event that you receive a call from somebody who's incarcerated, most likely that call is also going to be recorded or monitored. You will get a recorded interruption, usually that says, this call is from this particular facility. So just keep that in mind, that if you want to speak to someone confidentially, you have to set it up from your end, and your client, will unlikely be able to call you in a confidential setting. So the next part is legal visits. A lot of this is similar. Setting up the visit, you definitely want to confirm the visit procedures, and you can either call the institution or email them to set up the visit. And again, you want to have all the necessary info: client name and number, your attorney ID, and legal call contact number, and then your availability. And so one of the things, like for the BOP, if you haven't been to an institution before, you might need to fill out what's called an NCIC check. It's like a background check. And then you also have to fill out a form if you're not an attorney, if you're going in as a representative and attorney. And depending on their timeline, this could take, a couple of weeks. So if you do want to visit someone, you should, plan to have the paperwork ahead of time. In the DOC, if you're visiting someone, that person has to add you to their legal visitors list. And there might be particular information that they need, like your name, your attorney ID, and then your date of birth. So your client would have to add you to their legal visitor list in order for you to set that up. And then you would set that up, and you might need other documents like a gate pass or different things like that in order to actually go in and visit your client. No matter what paperwork you need and what you need to do ahead of time, on the day of the visit, you want to make sure you print out everything that would confirm that you're going to be able to go and visit your client that day. And if there's any contact information from people who set it up, from people who confirmed to you, you want to write their emails, names, and numbers. So that in the event that you get there and people say, oh, you don't have your paperwork, you can say, oh, well, can you contact any of these people, or like, here's my copies. I've had this happen at the BOP where they didn't have the confirmation, and I was able to show that to them. And then in addition, there's other different rules that prisons might have about what you can and cannot bring in. So for example, at the BOP, the facilities that I've visited, you have to write down your vehicle license plate number, and then you have to hand in your vehicle key. You can't bring that in with you. If you have electronics like a Fitbit or other things, you can't bring phones or electronics in. And then any paperwork that you have, different things, you might have to be scanned. And then once you're in the visit, you want to assess the confidentiality of the visit. Is your client comfortable? Are they in an enclosed room? If there is a glass between you, depending on the security situation, and you have to use a phone, is there any concerns about that phone being monitored? If not, or if there's a camera or something, you can also just try to speak through the glass to your client. And then if there are windows or cameras or staff outside, can they hear you or see what you're doing? And then if you have documents, I usually try to make sure that the documents are covered, or that I'm taking notes, and those notes are only visible to me or something like that. So, and then I think overall for both visits and calls, following up with your client after is a very good move, just to make sure nothing negative has happened if they've experienced any retaliation or concern, and also just to keep the communication open with them. Alex?
I was going to just throw in a few other kind of like attorney tricks for when you're going on visits. Things that we don't normally think of, so it's become common for us to realize that we always need to have our most recent attorney license from the PA bar. And we as people who are in prisons all the time carry it with us all the time. I know most other attorneys might not even know where that little card is. You need to have that card as well as a picture ID with you when you go into prisons for visits, because most in the State Department of Corrections, they require to see your attorney license, and some of the county jails do as well. The other thing is to think about both what you're wearing and what you're bringing with you, as far as like, I don't like legal pads. I prefer spiral notebooks, but there are certain jails that won't let spirals come in because of the metal. There are certain jails that won't let pens come in that you can pull apart. So I have like a set of notebooks and pens that I know can get through most prisons and jails. And when you're looking at what you're wearing, you want to minimize the amount of metal that you're wearing. As tends to be the fact in society in general. There's more of a glance at what female presenting attorneys are wearing when they come in. So you want to make sure that it's very conservative, that you don't have generally, wireless undergarments, and no sparklies or metal bits in your shoes, because all of those things can get you flagged and you can't get through the metal detectors, and then you can't have any visit with your client at all. And there's some jails and prisons, for example, even if you're in a suit jacket, if you've got like a sleeveless blouse on underneath your suit jacket, they still won't let you in. So you need to just have like, shorter long sleeves and things that can get through the metal detector. And sometimes we also will have like just like a change of clothes in the car that's like extra, like, we might sometimes you just have to switch into jeans because you can't get your work clothes through. So just have those alternatives in mind, especially when it's somewhere that's more of a travel to visit with your client, because they can enforce those rules very very strictly. And the other thing to note when it comes to especially the Department of Corrections facilities is don't use any kind of hand or body lotion that day before you go to the visit, because a lot of lotions can set off their little ion drug sniffer devices for false positives, and they don't always wash off right away. And if you set those off, you can't get in to see your clients either. So it's a good idea to not wear any kind of lotion the day that you're going to visit.
Yeah, and then just the last thing, Sierra mentioned checking ahead on the rules. So you might have to get a gate pass to allow you to bring in materials or to get your client to sign materials. Otherwise, like and that rule will vary. So I was actually used to not having that rule. And then I went to visit a prison and I had to go in with nothing and memorize what my client told me. I'd already traveled 2 hours. I was still going to do the visit, but couldn't even bring in my legal pad and pen because I didn't have the gate pass. So it's 1:30, so let's move on to Alex, and you can talk about medical care.
Yeah, okay, great. And so I'm just going to give kind of a short overview on medical care and issues relating to that before we switch over to Ming talking about medication for opioid use disorder. So with medical care and mental health care, both of these things are constitutional rights that your clients are still entitled to when they are incarcerated. And when people are first admitted to a county jail, during the first 24 to 48 hours, they should be evaluated at intake by the medical department, where they have an opportunity to identify any conditions that they have, any medications that they're currently being prescribed, as well as any other existing health concerns at that moment. During that intake, they say what medications they provide. Some county jails will then allow family members to bring in the prescription bottles, and some county jails will require the medical departments to like put an order in for those prescriptions. But if there's any medicines and prescriptions that your client is taking before they are incarcerated, they absolutely have a right to continue having medicine for those conditions while they are incarcerated. There are frequently issues as far as, the brand of a specific prescription and things of that nature that can need to be discussed with the medical department at times. But that right does exist. And Ming will talk a little bit more about how with some types of medicine, it's a little bit harder. When it comes to medical care, that includes ongoing care for any conditions that people had before they were incarcerated, chronic care conditions as they're moving forward, as well as for people who are incarcerated longer than just a few days in the county jail. You have a right to continue, regular health checkups. So for people who are in state prisons, you should have a physical every year. You should have for people with uteruses, you should have, they have rights to gynecology appointments, birth control. All of those things are encompassed in the right to medical care. So a lot of people in general society kind of think like when you're in prison, you don't have access to anything. When it comes to medical care and mental health care, the prison should not be cutting off your access to those cares. And people have a constitutional right to that care. And that includes, when it comes to mental health care, having access to psychiatric medicines, as well as having access to counseling and therapy and talking to a psychiatrist. Now, of course, in your county jails, that's a huge problem that we're constantly litigating and dealing with. But that is definitely, people have the right to that. And if you have a client who is in need of some kind of mental health care treatment and they're not receiving that while they're in the county jail, please reach out to us. And you can also, something that can be very helpful in getting access to medical care for people when they're first admitted to county jail is if there's some kind of dispute with the medical providers at the jail about whether or not some kind of prescription or something is necessary. If you can have your client sign a release form allowing their primary care physician in the outside community to talk to the jail or provide a letter saying like, I've been treating this person for this condition for such and such, and they require this, to kind of verify conditions, because county jails don't always believe people as far as what their conditions are. And so that's something that can be very helpful in getting care sped up, is getting a letter from the doctor on the outside about what their care they were receiving was. Another element when it comes to medical care is that for people with chronic care conditions that require more daily monitoring, the right to medical care includes having that kind of monitoring. So if you're an individual with diabetes, you should still have, and when you were outside of prison and jail, you were someone who needed to check their blood sugar multiple times a day. The client still should have the ability to do that. Their blood sugar needs to continue to be monitored. They should still have access to insulin. Asthmatics should still have access to their inhalers. If it's someone who has what we kind of call it a keep on person inhaler, that's something that the jail should be providing as well. So any issues that arise where someone doesn't have access to the care that the prescriptions and care that they were receiving on the outside, that's something that can be brought up with the jail, and pointing out that the client does have a constitutional right to that medical care and that mental health care. With respect to like what your actual constitutional right to medical care is, it's what's called, for people who have been convicted, it's the 8th Amendment standard, which is it's called a deliberate indifference standard, which means that there has to be a serious medical need, which basically means anything that a physician has diagnosed and says requires treatment, that'll end up being a serious medical need. And then the jail staff needs to know of and refuse care, or provide care that causes additional, or fail to provide care that then leads to additional pain and suffering. And so, the first element of that is that the prison needs to know about the medical need. So if you have a client who's raised with you, hey, I need, I'm being denied my medicine, or I'm having headaches all the time, or I don't feel well, like make sure that they've put in and asked to see the medical, to talk about it. In a lot of jails and prisons, it's called putting in a sick call request. And then after that, if they're still not getting the care that they need, that you should tell them that they can fill out what's called a grievance form. And that's a way that you can notify the administration about what's going on. And then also you as the advocate can, with your client's consent, because medical care is even more, in a lot of ways is even more confidential than, our other conversations at times. Make sure your client's okay with you calling the administration, but something that we have done on occasion and any lawyer can do for their client is just to call up the warden and ask to talk to the medical department and be like, hey, I'm hearing from my client that they're not getting access to this, this, and that, because what we see a lot, especially in jails, is once they start getting calls from the community or from people outside of the jail, they'll take that extra minute to actually pay attention to what your client's saying and what your client's complaining of. So sometimes all it takes is just that phone call to say, hey, my client's having a problem with this. Can you, visit with them? What's going on? And so that's a step that can be very, very helpful for clients in receiving care. And then if there's also kind of an open area in the law as to what the constitutional standard is and should be when it comes to medical care for people pre-conviction. At the very least, it is that deliberate indifference standard that we were just talking about. However, there is some case law now that has what's called an objective reasonableness standard, which is a much easier standard for people who are seeking medical care. And so that's just something to kind of like keep in mind when you're talking to prisons and jails. I think the big point is just to remind them that absolutely, like, your client has that right to medical care. And it's one of the kind of weird things about our health system in this country is that people who are not incarcerated don't have a right to medical care. But people when you're in prison and jail absolutely do have that right. And because society has taken away their ability to make those choices and to seek out care, the jail and the counties have, the jail and prisons have the obligation to provide care and to give them access to doctors. And a lot of times there can be issues due to low staffing at the prisons and jails. And so it can take a lot of stubbornness and perseverance by clients and outside community members to keep pointing out, hey, they haven't seen anyone. Hey, they haven't seen anyone, like writing grievances, writing request slips, people calling in. And that's one way to kind of push forward and get care. And that was a really quick overview because I wanted to leave plenty of time both for questions and for Ming to talk about something that we've been focusing on lately, which is getting access for medication for opioid use disorder.
Yeah, so this is one, I consider this issue to fall under what Alex just said. As many of you likely know, there is a opioid overdose crisis in the United States and in Pennsylvania. Some of it, I think, became a little more hidden during the COVID pandemic, but in fact, many people have suffered even more during that time just due to the stresses that the pandemic has brought. And it's probably not a secret that many people who do have opioid use disorder kind of often may come in and out of jail or prisons and have intersections with the criminal legal system. So unfortunately, though, even though this certain things like methadone, Suboxone, Vivitrol are prescribed medications, they are not often frequently provided for in jails and prisons. There's a growing movement, I think, to a greater understanding as people understand science behind it. But there's a lot of stigma around it. There's a belief that, hey, people just want drugs. You can just, get over this using your self-will. It's a matter of you just need to like participate in programs like, people who suffer from other substance use disorders or things, might be able to successfully navigate that through groups and things like that. But that's often not the case because of the way opioid use disorder is. It literally changes the structure of your brain so that really it makes just using for for sheer will not an effective practice. So the growing science and scientific research shows that these different types of medications really can allow people to successfully thrive in life. And as I mentioned, there are three main categories: methadone, Suboxone, and that can be in combination with others, and naltrexone, which is the brand name is called Vivitrol. The other side effect, if you will, of jails and prisons not providing these is actually there can be a very large black market. And if you are caught with, say, Suboxone, then you end up sometimes with misconduct, which can have consequences of you not getting out for parole, being placed in solitary confinement, and things like that. And to me, that's really for folks who are accessing that Black market in prisons and jails. It is, to me, sort of a desperate attempt at trying to really navigate your body's reaction to not having those, because it was fundamentally changed from opioid use disorder, and using the Black market to try to have your way of coping through just regular life. So we have a partnership with Vital Strategies, and we've really worked to focus on increasing access to medication for opioid use disorder in jails and prisons in Pennsylvania. And so we have an attorney and a paralegal who we've hired, and then we also have an independence fellow who's just joined us this week to also work on this particular issue. So the first thing I want to say is, please, if many of you, I imagine, are in legal aid programs across the state. So if you have clients or know of people, they are going to be incarcerated, they are incarcerating, and they are dealing with these issues, please refer them to us, because we now have some dedicated folks who are working on these issues. One element of our project is we've been submitting right to know requests to every county jail about what their policies and practices are. So what we've learned, so far we've gotten 48 responses, and there are over 60 jails, I think. But of that 48, 11 jails have absolutely nothing. So when an individual who is incarcerated, they are basically forced to withdraw, which is incredibly painful. And it can last for days, weeks even. 37 of those 48 say they have MOUD or MAT. And I'll just note, as a terminology, this is something I learned, but the term advocates favor is medication for opioid use disorder rather than medication-assisted treatment, partly because I think the science shows that medication alone is very effective. Oftentimes it's in combination with other types of group programs or programming, which I personally think can't hurt, but the medication is a really critical aspect of it. So we kind of call that MOUD. So 37 of the 48 said that they have a MOUD program, but if you look more closely, it's actually pretty limited. So maybe they only offer Vivitrol, which is not as effective as the other two. And for those who are more interested in the science behind it, you can look at the difference between an agonist or a partial agonist or a non-antagonist. So basically, for purposes of today, methadone and Suboxone are more effective because of the way they interact with your body. Vivitrol is typically given to people upon they're about to be released. And the reason is because why this is such a public health crisis is that for those who are in jail who do not receive this medication, they are released, then their chances of overdose and unfortunately death and relapse is incredibly high. So not to mention that it's like, they're suffering while they are incarcerated if they don't have access to these medications. So anyway, so of those who say they provide it, they might only provide Vivitrol, or they only provide it to pregnant people and only while they're pregnant. So once they stop being pregnant for whatever reason, they are cut off and once again must go through forced withdrawal, or if there's a court order. And, not every person might have that court order. The Department of Corrections in 2019 did implement what they call a MAT program, but they do have certain criteria. And so that's something we're taking a look at. I think it did have some influence on county jails implementing programs, but not across the board. And what we've been seeing in terms of the clients who contacted us, we have a number of clients who entered county jail. That county jail doesn't have it. So then they go into the Department of Corrections, and the Department of Corrections will look, too bad you weren't on a program. And that's because the county jail didn't offer it, even if they were successfully on that program for months or years even before entering that county jail. So in terms of what I think our organization is working on ensuring that your right to medical care does, that jails and prisons understand that this should include access to medication for opioid use disorder. So far in litigation, there have been a few successful cases nationally brought by the ACLU for people who are about to enter incarceration and showing that they absolutely must continue that medication. And then in our case, through this project, we have assisted a few people on trying to advocate for people once they're entered and they're forced to withdraw. And just last Friday, we filed a complaint, Strickland versus Delaware County. Our client was stopped at a traffic stop, had bench warrants because there were some hearings that he didn't appear at relating to unpaid costs, fines, and restitution. So it wasn't even a new criminal charge. It wasn't even a parole violation. Gets picked up, brought to Delaware County. He's been on methadone, kind of like many people who struggled with addiction, had periods of success and relapsed through for the past 25 years, finally was doing really well over the last 18 months. And then on a methadone program, a fairly high dose, brought to Delaware County and then forced to withdraw, enduring many, many weeks of incredible pain and suffering, because withdrawal is very painful. We ended up filing a motion for preliminary injunction in TRO, and then coincidentally, the next day they released him. So I don't know, in our line of work, that we consider that a success. At any rate, so a couple things, I'm just going to use one last minute, is based on what Alex said, you have to kind of establish a few things if you're going to bring a case in. And the courts really have now seen that withdrawal is a serious medical need, recognizing that it can be incredibly painful. And now more and more courts are recognizing that opioid use disorder is also a serious medical need. And based on the criteria, I think if you present it, hopefully the court will see it that way as well. And then whether or not the prison has taken the reasonable steps. And in the Third Circuit, there's sort of ways you can establish a constitutional violation. But one of them is like, not providing, there's a need for treatment, but nevertheless you deny that, and that causes suffering. Many of our clients are going through that. Or you're denying it for non-medical reasons. So many of the jails have a policy that they will not provide it to non-pregnant people, in which case there's no individualized medical determination that this person in fact needs the medication. So you kind of think about it like someone with diabetes who's been on insulin, they're on the outside. If they go and they're incarcerated, well, sorry, our policies, we don't provide insulin, or we don't provide the medication for diabetes. That would just be really unfathomable. And people would understand that to be cruel. You have to have at least an assessment of that need for that medication. So, and then the last is, if it falls under the ADA, I think it does. And several of the courts have found that the person with opioid use disorder, that does constitute a disability under the law because it affects major life activities. And then looking at whether or not that prison or jail is discriminating against that person because of disability or failing to accommodate them. So once again, if you have clients or people who are about to be incarcerated, are incarcerated, and they would like access to medication for opioid use disorder, please do refer them to us. We'd very much appreciate it. All right, so there's 10 minutes. We'd like to open it up for questions. And
I see that there's already a question in chat that kind of refers to when I was talking, so I'll go ahead and take that first question. So the question is, what if they need care or medication but were not receiving before they were being incarcerated? So the right to medical care absolutely encompasses any medical needs that develop while a person is incarcerated. So for example, especially in our state institutions in Pennsylvania, given the high number of juvenile life with parole and other life without parole sentences that have been handed out, we're constantly dealing with the issue of an aging prison population, which means we have thousands of people who are developing even more serious medical needs as they age. And any of those needs that develop or that come up while a person is incarcerated, absolutely they have a constitutional right to have any symptoms or any medical need both addressed by staff and they to have an evaluation by medical staff and treatment, as well as when the need or condition is serious enough to be referred for outside treatment, taken to an outside hospital or specialists, and to have any kind of testing or surgeries or anything related to that. Everything about medical care is covered by the constitutional right to medical care, though some prisons and jails don't always feel that way, as Sarah was just talking about with MOUD, but so someone doesn't have to just have a condition at the time that they're admitted to the jail to be covered by their constitutional protections.
While you're waiting for other questions, this is Kelly. I'm just going to go ahead and launch the second CLE poll box. I will leave it up for 2 minutes. Attorneys, please respond and feel free to continue. Thank you.
Okay, great. So there's another question which says, thanks. So could a person who's using opioids when arrested then request a MOUD upon incarceration? So the answer is yes, they absolutely should make that request. And that's actually the case for any medication. Typically, when you enter jail or prison, there should be an intake process, and that's they have to make it sort of best practices, or they're supposed to meet with you, ask you a lot of questions, including like assess risks of self-harm, and also your medical care. So that individual should make that request. And, depending on the jail or prison, they will respond. It depends on the response. And then if for some reason that is denied, then they should also take a look at what processes that jail or prison has for making that request. So we usually advise people to use both sick call slips, medical request slips, as well as grievances to make that request. It can be made even stronger to the extent that you have documentation that you might have or be able to get from your doctor or the health center that you've been going to establish that, because sometimes the prisons and jails do want to confirm certain things before they provide that. Any other questions?
Okay, so one thing that I kind of rushed through and didn't talk about because I wanted to make sure that Suming got to talk about MOUD, but since you don't have any questions, I did want to get a little bit on my ADA soapbox for a couple of minutes, which is that the Americans with Disability Act is an incredibly powerful statute that covers a lot. And actually I will pause. And there's a question of best ways to initiate intake, and can a third party do it? So it should be a required, almost every jail I know of does have an eval at intake. Sometimes it can take a day or two, which can, depending on how backed up they are. And so what we've done in the past, when we've heard that there are people who are in intake and they have not yet been seen by medical staff, is we'll call the warden and say that we've heard that there's a client who's there who hasn't been processed yet. And that's really kind of the only way to do it. Initiate intake with our organization. Sorry. So the best way, for other advocates, you can just email or call any of us at our offices. As far as for people who are members of the community and clients, we do tend to prioritize letter intake, but we also do have intake staff who answer the phones in all of our offices as well to answer any questions. Go ahead, Ming.
I was saying, in particular with this issue, because it can be time sensitive, like let's say someone just entered and they're being denied, then I would say feel free to call us. The attorneys who are working on this are Adrienne Abner and Sarah Bleiberg, and the paralegal Charlene Rojo Reyes. So you can reach out to them directly, or any of us, and we'll refer it. But typically, yeah, we do mail. And then ultimately you asked about the third party. So yes, we often do get the first contact from a family member or an advocate. Ultimately, we do need to have contact with the client, as with typical with legal aid, because we need to make sure they agree to us helping them. But certainly someone from the outside can contact us first if needed. Alex, did you want to continue with the ADA?
Yeah,
if anyone else has questions, just put it in the chat.
Yeah. So the ADA, one important piece about the ADA is that it is a very broad statute that protects people in a lot of circumstances. And, and society has a very ableist view on a lot of things. And we think of people with disabilities as primarily being people with very obvious physical needs, such as people in wheelchairs or things of that nature. However, the ADA itself covers any kind of physical or mental impairment that substantially impacts a major life activity. So that includes anyone with blood disorders, diabetes, mental health needs, people who opioid use disorder. So any kind of medical or physical condition, if it is having an impact on an individual's ability to think, sleep, go to work or any of your actual bodily processes, all of those things can fall under the as qualify as a disability. And that's a really important thing to look at, because the ADA in its anti-discrimination mandate has it both. There's the need to provide accommodations to individuals so that they can participate in programs and services and activities to the same level as everyone else, but also this prohibition against discrimination just because a person is disabled. So for example, the fact that with, the great examples with MOUD. So the fact that, people with diabetes can get access to their insulin generally, but people with opioid use disorder, that's one particular condition, disability, that the prison or jail has made a policy that bans the treatment, which would allow them to participate in activities. That's discrimination. And so it's always, the ADA is a great way to look at the situations that your clients are going through and think about ways that the jail or prison is failing to make sure they have access to things. And that also includes things such as people who have sensory disorders, and making sure that they're housed in ways that don't result in additional issues for them, or people who have experienced trauma and can be triggered by some of the things that happen in prison and jail. The prison and jail does have an obligation to modify their policies and practices based on to accommodate those disabilities. So it's something that we as advocates should always be looking at and keeping an eye on, because especially when it comes to the prison and jail population, it really is going to be the vast majority of people who have who are protected by that statute. And it is a statute that is a lot easier to make arguments under than the constitutional standards at times. So it's something to always keep an eye on and ask clients about.
Okay. So any last questions? So I think there's only a minute. I just want to note that for we're happy to be a resource for, and I think I just saw the participants list. Some people on the list are I know, have had a lot of communications and contact with clients who are incarcerated. But for those of you who don't and have questions or run into issues, feel free to reach out to us. We're happy to be a resource. I think part of the reason why we have the three of us is because we're all across the state. So feel free to reach out to any of us or anyone else with us, and either on just tips on how to get in touch with someone, or navigating some tricky issues, or accessing medical care or MOUD, or anything else relating to conditions for people who are incarcerated.
Okay, well, thanks for being with us today and for the great presentation. It was full of a lot of, at least to me, new good information. So everybody have a great rest of the day.
Thank you.